Good morning. Is this on? Okay, good. My name is Chris Rizek. I'm a practitioner here in Washington, Kaplan, and Drysdale. And I want to welcome you all to this conference and start by thanking the sponsors of this conference, the American College of Tax Counsel, the ABA Tax Section, our friends at Tax Analysts, and the American Tax Policy Institute, not to mention Nina and the IRS. Which has done a fabulous job in organizing, and I think everyone will agree, and I think they deserve our thanks, and I appreciate that. My panel this morning is about sort of the theoretical basis for taxpayer rights and how that translates into good tax administration. And I have some fabulous panelists that I want to introduce. First, to my immediate right is Duncan Bentley from the University of Victoria in Australia. Duncan, we learned last night, grew up in Africa of an English family, went to university in South Africa, has lived in Australia for a long time. He's been quite the world traveler and has an extremely long string of letters behind his name: BA, LLB, LLM, LLM again, PhD, and then some I didn't even know what they are: FCA, CTA, FAAL. I did not see KB, QC, or MP on there, but I think pretty much everything else. And we're extremely honored to have Duncan here. Duncan has also written extensively on taxpayer rights. Nina introduced me to him and his book, Taxpayer Rights: Theory, Origin, and Implementation, which you should all go buy on Amazon. I did not, however. I got my copy from the Library of Congress. It's very hard to find on Amazon, Duncan, I'm sorry to say. Our second panelist is Giovanna Tieghi, who is from the University of Padua, also a very distinguished lawyer. She works in the court in Padua and has a PhD in law on the theme of taxpayer rights. She has been a visiting professor here in the United States at a number of universities with LLM programs, and actually spent some time in 2006 on a sort of a fellowship at the National Taxpayer Advocate's Office. So we're very happy to have her here. My third panelist, I think many of you know if you read Tax Analysts, is Joe Thorndike. Joe has a PhD in history from University of Virginia and writes extensively in the area of United States economic and tax history. I think his current book out there is about the Treasury Department, 1500 Pennsylvania. He also wrote one that many of you, I know I read when it came out about 3 or 4 years ago, called Their Fair Share: Taxing the Rich in the Age of FDR, which is very interesting. And he's a regular contributor to Tax Analysts. I think he's actually the director of the Tax History Project, which Tax Analysts sponsors. And so I was delighted to see him. I do want to read one of the comments on his last book. Joe Thorndike is the Alexis de Tocqueville of tax culture, a lucid, nonpartisan guide shining light on the idiosyncratic, oft-surprising events of the past. I would have been embarrassed to put that on my website, but it was on his.
Don't believe what you read on book covers.
Well, it was by Amity Shlaes, and Amity is not prone to overstatement, so I thought that was pretty good. So we're going to start with a presentation from each of them, and then we'll have some discussion. I've got a list of questions for each of them based on the papers they have submitted and on what their presentation is going to be about. I would encourage, if any of you have questions, there are microphones on either side of the auditorium, or raise your hand and shout in the middle. This is being videotaped. I'm ready for my close-up. Are you ready for your close-up, Mr. DeMille? Okay. You will need to speak up, but don't feel shy about interrupting with questions. I think it'll be much more useful as a conference and an intellectual discussion if we have some give and take back and forth. So I would start by asking Duncan to go present his paper, and then we'll get right underway.
Thank you very much. One of the things that, just make sure that these are high enough. One of the things of which you'll all be very much aware is that we are entering an era of digital transformation and global transformation, and we see that all around us. But if you imagine back into the past, the time of the Roman Empire, similar international upheaval was taking place. If you think back a few hundred years later, the great age of exploration, when the globe was opened up and transformed, and then a little bit later, the Industrial Revolution, which completely changed the world of work and the way we live. And then a little bit later on, we came to the 20th century, and some of you who are as old as I will have had grandparents who lived through the introduction of the motor car, the aeroplane, and most of us here are old enough to remember the introduction of the internet and the way that that has transformed our lives. And one of the problems we face is that with a 19th and 20th century largely tax system, it is facing challenge and disruption. Now, if you think of tax, it's an exaction of property by the state to fund the state and the society in which we live. And this presupposes the right to own property and the operation of the rule of law. What I'm going to do in my presentation is to, hang on. I'm just, there we go. It helps if you learn to use a mouse in the 21st century. I'll try and use this other thing, which will be easier. The basis for taxpayer rights is what I'll look at first. The increasing importance of context and meaning. The expanding and permeable definition of rights and enforcement. And the critical importance of engagement. Now, the basis for taxpayer rights is obviously the rule of law. It's fundamental that taxpayer rights are based in the rule of law, and that the tax administration should observe basic taxpayer rights in the application and implementation of the law. And the more rubbery the rule of law is, the less likely we are going to see the observance of genuine taxpayers' rights. And this is becoming widely accepted. And if you look at the OECD survey, which is put out regularly, which examines about 30 countries across the world, it measures jurisdictions' observance of basic rights as well as the basic administrative structure and operation of tax systems. And this is supported very strongly by the compliance research, and we're going to hear quite a bit about that over the course of the conference, which consistently shows that the more you have trust between taxpayers and the state, the more likely that taxpayers are to voluntarily comply with the law. But trust is founded, I would argue, in the rule of law. And when you look at the rule of law, there's an agreement when you're setting up a tax system to the basic principles which are necessary for its operation. There's an agreement that we should have equity and fairness. People need to expect that the tax system is going to be fair. They want it to be certain. They want it to be understandable. And of course, it should be as efficient and effective as possible. Obviously, these are competing principles, and they must balance. And then overlaying the principles on which the tax system is designed, you then have the fundamental legal rules which give effect to a comprehensive and coherent tax system, and to which most jurisdictions would subscribe. So there's an agreement that tax must be imposed by law. There's an agreement that it should be published. People should know what the law is, that in most cases it should not be retroactive. And tax laws must be possible to be obeyed, otherwise it defeats the purpose. They should apply to everyone within a set group, and they shouldn't discriminate. They shouldn't be applied twice, and taxpayers should generally have access to both the courts and to representation before the courts. And those are the fundamental rules based on the principles. But what we're increasingly seeing is an overlay of additional rights which are given to taxpayers through the operation of the tax system, and particularly in states where the rule of law is strong and effective, what we're seeing is the growing up of a large body of soft law and the extension of legal rights to what I call pragmatic rights. They don't have any force as such in law, but they become the rules by which the tax system operates. And that draws us then to the increasing importance of context and meaning. And we have to understand that we aren't in a box when we're talking about taxpayers' rights. It isn't a closed system. It's a system which is informed by the societies in which we operate, and there are multiple influential and key actors who are impacting on the operation of the tax system, the tax law, and therefore they impact on the context and meaning of taxpayer rights. Because although we might have fundamental agreement on what rights are, what things mean, we might have similar languages, we might have similar legal systems, in actual fact we can mean very different things as soon as we move across a border. And even within a system, you can have very different understandings of meaning. Let's give an example of the actors and how this can vary. Most of you will have heard of the BEPS and the business enterprise profit shifting, and the issue of fairness between nation states in collecting tax. And so just to give you an Australian perspective, Australia fully supports the BEPS, and it's introducing its own law up front to combat profit shifting. It wants to get ahead of the game. And the political tax inquiry into this by the Australian Senate effectively said the federal government must take unilateral action on corporate tax cheats. You're getting the flavour of it. And the chair, Senator Dastyari, said the report should come as a wake-up call on how Australia is being fleeced by some multinational tax avoiders, mainly from the US. Now, we're not talking law, we're not talking rights, but we're talking about the context in which the tax system operates. But then the Australian Treasury is a much more balanced, pragmatic body, and it takes an economic view, and it says that we should impose tax only where the economic activities generating the profit are performed. We're still not talking law, we're still not talking rights, but we're taking a perspective on what the system, how the system might operate. So then we have the draft law, and the new measure will apply to schemes if under or in connection with a scheme, and you get the sense. It goes on for pages of definition. And immediately we have a specific rule with clear and defined terms, which are far narrower than other political or the economic context, but it's still pretty broad, and it requires the exercise of another actor, the Australian Tax Commissioner, in making determinations as to when a benefit, for example, might be cancelled. And it doesn't just affect the taxpayer themselves, it affects those who are connected with a scheme which a taxpayer has been involved with. And so we're seeing the practical application of the law in its implementation is far-reaching. And how the taxpayer can respond to that and what rights the taxpayer has can be pretty nebulous, because if the tax commissioner acts in accordance with the law and makes a decision based on firm and solid reasons which are given to the taxpayer, under administrative law there isn't a lot of scope for that to be overturned unless there has been an error of law. And so we see that the law, as is broadly stated, and how it is applied will determine really how the taxpayer rights will play out. But if we go back to the political view for a moment, we look at a jurisdiction with which Australia has a lot of dealing, and we look at the multinational corporations' state of origin, the United States. We have the leaders of the US Senate Finance Committee and House Ways and Means Committee who disagree with Senator Dastyari in Australia about multinational corporations all being tax cheats and fleecing countries. And they say Congress will craft the tax rules that it believes work best for US companies and the US economy. Different political contexts, and this will likely mean different laws, different application, and a lack of congruence. And the taxpayers are caught in the middle. And you might say, well, that doesn't really matter because we're talking about large multinationals who can afford to ask Chris to advise them, and the Big Four and other groups like that. But over the last few years, we've seen a proliferation of free trade agreements. You've seen trade missions which involve hundreds of small and medium-sized enterprises, small traders, who are all becoming part of this multinational global commercial operation. And with the internet, this is only going to grow and expand. And so what we can say is that we have an expanding group of people who are being subject to quite nebulous forms of different contexts, different meanings. And so we have expanding definitions. So legal rules, as we know, are easily enforceable, but there are grey areas, areas where the revenue authorities have to make decisions. Provided the legal rules work and are enforceable, the compliance frameworks have shown that it's in the interests of the revenue authorities to implement and observe a range of cooperative soft law options that encourage voluntary compliance. And these can range, as you would know, from rulings to alternative dispute resolution mechanisms, safe harbors, and genuine consultative approach to problems which are facing taxpayers. But these give rise to legitimate expectations which are not set in stone. It then becomes a sort of soft law, which is enforceable by administrative practice rather than by legal fiat. And ombuds often hold the revenue authorities to their service standards and their published promises on the basis of legitimate expectation, in a sense. And revenue authorities measure themselves against those very same standards. And it's driven by self-interest. Building trust builds voluntary compliance. And these provide pragmatic rights, and the scope of these is expanding. But we have to be very, very careful, because if we water down the legal rights, it can undermine the whole system. And it's like building a large edifice where you build and build up top without adjusting the foundations or paying attention to their repair. It can all come tumbling down. And that is something which we must be aware of, that it is a whole ecosystem, as it were. And as with the compliance framework, the effectiveness of soft law and pragmatic rights depends on the presence of effective legal rights standing behind them. They're like the flesh on the skeleton, as it were. And that brings us to the critical importance of engagement. And everybody has a vested interest in the system working, which is why you have so many actors constantly involved. And as we see budget cuts, massive changes to the tax system, the threat to the revenue base, which is coming upon us very speedily, which gives rise to those political fears which you heard me talk about earlier, it's easy to assume that, well, it's all right. We've been going at this for about 30 years. We have a very robust system which voluntary compliance is working really well, and it's easy to assume that it is firm and set in stone, until you start looking at something like the Volkswagen scandal, which struck a while ago. Until a month ago, we probably thought that Volkswagen, German engineering, trust, reliability. And I fear that reading the 2014 report by the National Taxpayer Advocate, I have to question whether we need in all jurisdictions to be looking at the whole ecosystem, the whole framework, to see if we are looking after and guarding all of it. The more taxpayers and representative bodies are engaged in what society sees as a better and more effective and fairer operation of the system, the more taxpayers will engage and voluntarily comply. It's positive reinforcement. But political scientist John Keane has come up with an argument that we move from representative democracy to monetary democracy, not monetary, monetary. In other words, it's democracy by monitoring. Globalization and digitization will force tax systems to engage with the transparency of the social media and total transparency and engagement across borders. And as the interrelatedness of trade flows grow, so you'll have TripAdvisors for country investment, and part of that will be taxpayer rights and how taxpayers are going to be treated if they invest in or go to live in those countries. And increasingly, voluntary compliance with taxpayers' rights by tax administrations will become as important as voluntary compliance by taxpayers. Otherwise, investment flows and mobile populations will vote with their feet, and you'll have a consequent loss of investment and revenue, which is exercising people like the politicians and the Treasury. And so we need to build that complete framework and take advantage of the opportunities which modern society offers and recognize that it's a combination of the rule of law and a fair tax system which operates in an environment of trust, which is one of the fundamental planks of a thriving state. And my caution would be that we must do it in the context of a rational and sober analysis of the whole context with all of the actors involved, particularly those who have a key stake, and make sure that we don't become the playthings of political posturing and horse trading and lose the opportunity for decent debate. Thank you.
Giovanna, would you like to go next? Giovanna noted that she had also written a book which the title, unfortunately, is in Italian, which, if compelled, I will attempt to read. Fiscalità e diritti nello Stato Costituzionale Contemporaneo, il contribuente partner. That is, fiscal rights in a constitutional context, the taxpayer as partner. That was with the help of Google Translate. Giovanna, would you like to?
Thank you, Chris.
Thank you.
Thank you, Janica, for your precious remarks. Before starting my speech, let me really deeply thank Nina Olson for the invitation. It's my particular pleasure to be here, to be a representative of the University of Padua, and to be part of this great event. Organized, I perceive, with a double aim, sharing academic and professional interests and giving us the chance to challenge a new way of intellectual growth through comparison between different legal systems in such a great variety of comparative fields. That's why primarily my speech will adopt an international perspective. Even if starting from the Italian case, the Italian Taxpayer Charter, the Statuto dei diritti del contribuente, law number 212 of the 2000, 15 years now since its enactment, serving the International Taxpayer Model Taxpayer Charter for its content. It's not yet serving the Italian system in terms of effectiveness. The challenge is of new strategies of comparative tax compliance, of course, but primarily of a constitutional consideration of taxpayer rights. The aim today is to encourage dialogue through observation, opposite points of view, to what I've been led to consider one of the most crucial issues contemporary democracies have to face. Today, context prompts the theme for my remarks, specifically focusing on the international issue of the constitutional perspective. Let's see the Italian and the US Constitution to represent constitutions all over the world. The constitutional perspective, which I propose to redefine for the purpose of effectiveness, the role of contemporary taxpayer rights and the role of taxpayer within contemporary democracies, a challenging path towards new constitutional forms of protections. Let me start from the following basic assumptions that will drive us through a journey I submit to your considerations. First, the unquestionable importance of the constitutional nature of the relationship between governors and governed in a given historical period. Let's think that it's interesting to note that the traditional civil law reference form of state, forma di Stato, to name that relationship is from a comparative perspective, just a way to consider from an Anglo-American perspective the concept of constitution, which in fact includes state-citizen relationship and involves beyond the rule of law, customs, traditions, jurisprudence, justice, and liberty. A process that starts from the law, namely its shape and its structure, and goes to the essence, to the substance, to the dynamic unit that outline the system of values and engage also the guardians of those values, the constitutional courts or supreme courts. How can this perspective affect the comprehension and, above all, the application of taxpayer rights? Let's lead to the second point, the need for a constitutional approach to explore how taxpayer charters can become an update roadmap for an effective tax administration. And third, the new role the taxpayer should take in an evolving constitutional state, from subject to citizen, from partner to customer. Considering this background, the key issue of the present speech can be outlined as follows. First of all, the relationship between tax authorities and taxpayers as a constitutional problem, investigated through an Italian original approach that figures out the importance of that relationship, governors governed, as it may be examined either putting authority and liberty on the same ground, liberal constitutionalism, or on different grounds, Jacobean constitutionalism. The lexicon used may concede when speaking, but it's the substance that to make a difference. Second, the search for a legal model and the legal technique that are necessary to let the TIBOR be a fundamental part of legal sources in order to respond, starting from the Italian case, to the promise of a taxpayer charters in terms of effectiveness. Third, the redefinition of a new role, the contemporary taxpayer, to accomplish an updated interpretation of dignity as item of balance between liberty and responsibility. Taxpayer rights are today a key issue in a system authentically founded on liberty. The study of the relationship between tax authorities and taxpayer defines the balance between authority and liberty and highlights the limit of a fiscal constitution. So become essential for a functioning of a democratic systems. Italy is a country whose cultural institutional matrix keeps close to a Jacobean angle, since when reasoning about constitution, it prefers the doctrine of the state over the idea that implies a mutually mandatory agreement. consequences are undeniable. The distance between citizens and system of power is enormous, especially between taxpayer and tax authority. A first feeling of reciprocal repulsion still persists. The result is an enormous waste of public money and unlimited tax evasion. That is the reason why the relationship consistent with what is called constitutional state is to be built. Experience gained in the common law jurisdictions, among other things, make it clear that taxpayer rights belong to the category of human rights, and that the perspective of human rights is based on tax compliance. So how can civil law systems, as experienced in Italy, find a way to embrace the premise of taxpayer rights being human rights? How can we just conceive the idea of tax compliance without a great effort to drop out the power perspective? And finally, does the dichotomy civil common law jurisdiction still have an influence on how taxpayer rights have to be considered, or is the traditional classification nowadays useful just for mere need of a systematic framework? The main issue for the comprehension of an effective dimension of taxpayer rights is the investigation of the decision-making process, which considerations and which criteria from the constitutional perspective should be taken into account from legislators, tax authorities, and above all, the Constitutional Court in balancing the interests of taxpayers, tax authorities, and state when considering tax rules where liberty and authority may conflict. The reviewed concept of person reveals important implications for the consideration and interpretation of the taxpayer charters. First, the necessity to overturn the principle of subjection and give new strength to liberty. Second, the compelling need to leave the so-called command and control approach and evolving that towards a shared responsive service orientation. Third, the time to focus on the honest taxpayer and his immanent active liberty. How to realize the change, to let the set of laws concerning taxpayer rights be effective, and how to design the path for effectiveness, including taxpayer liberty. The premise is changing the point of reference, including in the debate the free man, beyond that constitutional traditions quoted in the preamble of the European Union Charter of Fundamental Rights. To include rights in taxation, we have to rethink fiscal policy, building its premise on a dialectic relationship. We have to go back to the dialectic use of power. Traditions have actively contributed to lay the foundation of a system deeply rooted in liberty. To recall that system nowadays, we have to abandon the attitude of the servant and to acquire the attitude of a free man. Traditions unify fiscal and constitutional history to find their fairest balance between power and citizen, authority and liberty, which in this perspective leads to the dialectic representation of taxpayers' need. The experiences of constitutionalisms, therefore, find their basis not in the legal principle, but were born and are still fostered by virtues expressed in the above analyzed traditions, liberal or Jacobean, expression of a power challenging itself or not with responsibility. Let's shift to the second key point. Starting from Nina Olson's recent warning, she asserted, I believe a strong taxpayer bill of rights provides a roadmap for effective tax administration. If the tax system measures its performance through the lens of the TIBOR, taxpayers can be confident that they will be treated right and when they don't get the relief they hope for. Olson's recent words intercept the first profile I have introduced above. What is the meaning of a Bill of Rights? Which of the possible contents can be more compatible with its effectiveness in tax field? Referring to taxpayer charters as new instruments for a dialogue between tax authorities, legitimate power, and taxpayer protection and safeguard and satisfaction, the question sets on the role of taxpayer charters within the different institutional frameworks. First, as an application of the objectives of a Bill of Rights in tax field. Second, to help taxpayer rights be effective. The idea of exploiting the Bill of Rights as a way of correcting certain structural deficiencies in representative government, preserving the judicial supremacy of courts to interpret and apply laws, that idea seems to answer to the impelling current and widespread need to correct legislative excesses. Directly connected with the Bill of Rights as a structural corrective, an advanced stimulus has come from the suggestion to consider the target of the declarations of right in improving tax authority, tax administration, and taxpayer compliance. That can result, it has been emphasized from Professor Bentley, in spectacular cultural changes with the revenue authority with a major focus on taxpayer services. But at the end, how to help taxpayer rights be really effective? In my view, to become instruments of implementation of service standards, so to let taxpayer rights be really pragmatic, in fact, taxpayer charters have to be easy to understand and alive and dynamic pattern of the legal system in order to build an accountability network among different institutions, legislator, tax administration, and judges. Constitutional Court before anyone, Supreme Court before anyone. Considering the Italian situation, the regular monitoring activity on the e-Tibor every 5 years has given outcomes in terms of interesting feedbacks. Leaving aside ordinary judges, you can refer to my paper, and tax administration that perfectly represented by the interdependence and negative connection between tax authorities and the 21 Italian regional taxpayer advocates, who has proved to be a figure without a real independence and above all, without real powers and a perspective. As to be interpreted and felt as a figure without incisiveness, both by taxpayers and tax advocates. Leaving aside ordinary judges and tax administration, the very and probably the most pathological approach is the one adopted daily by the legislator, who operate as if Italian Taxpayer Bill of Rights did not exist, legislating while disregarding the law. To that dangerous deficiency, we have to add the inflexible position of the Constitutional Court not to operatively condemn legislative abuses and the evident violation of the Tabor in the name of formal justifications concerned with the legal formal position the Taxpayer Bill of Rights has in the hierarchy of legal sources, just an ordinary law, not a constitutional one, so as to become, just in that case, a judicial parameter for the declaration of unconstitutionality. The emphasis of the connection of the Italian Taxpayer Bill of Rights values with constitutional principle instead could have given the bill a leading place in the legal sources. Recalled by the Article 1 of the Tibor, declaring the provision of the Italian Taxpayer Bill of Rights general principle of tax system, underline that those principles are direct expression of constitutional principle, could have given the bill really a leading place in the legal sources. Serving the international model taxpayer charter, we have had to recognize we have had the recognition of a great ideal structure important going beyond the mere declaration of tax agents and obligations. As aimed by its founding father, Professor Marangiu, it expresses a broader vision of the world and of the law that escapes from mere procedure and inflictions and goes further toward the aim to realize integrity within the system. It served the international model properly because differently from other existing models, the Italian TIBOR realizes the normative fundamental base through broad principles, able to guarantee the reasonable, fair, and progressive new balance of taxpayer rights and obligations. Those broad principles, Nina Olson considers the approach that furthers voluntary compliance because it fulfills the promise of the TIBOR that taxpayers have the right to a fair and just tax system. But as we are testing, this is not enough. Does it still matter having a Bill of Rights clearly in book? Which is the impact of the non-justiciability, of non-accessibility of taxpayer rights by the Constitutional Court on the effectiveness of tax administration. Serving taxpayer implies letting the rights be enforceable and significant by constitutional system. And that not just to solve a single case, but to fix the person to whom those rights are connected at the center of the judicial review. Place for excellence, where the art to balance values causes precious to force a specific decisional moment of evaluation of people's needs and virtues in terms of dignity. This is the way to allow the taxpayer to be engaged and to contribute to a fair tax system. Italian experience speaks about principle ignored, rights relegated to paper. How to understand taxes and be compliant if the taxpayer's perspective is daily ignored. For the Italian taxpayer, a set of rules based on principle in tax field could have marked a real turning point if we consider that the self-qualification of the bill as law of direct fulfillment of the Constitution could have been interpreted as an explanatory support to constitutional principles. But to be strong, the Italian Taxpayer Bill of Rights could be essentially understood in its premises and promises, which primarily include the constitutional perspective. That means that the analysis of the non-exclusively Italian legislation based on principle has to be focused on verifying its compatibility with the idea of a taxpayer as a customer, and then with the possible implicit configuration of a particular subjective jurisdictional situation of liberty. It shows that taxpayer charters had to be based on two pillars, so liberty and responsibility. That is the context for a customer taxpayer and his pragmatic human rights. But some basic conditions have proved to be unavailable to push tax system to measure its performances through the lens of the TIBOR. First, a revisited interpretation of the principle of accountability. Second, an implementation of a protected involvement of the taxpayer, respectful of his liberty, right to choose between among alternative services, and right to a quality service with an organized set of rules. Recent specific proposals have to be taken into consideration to valuably protect taxpayer rights and choices in the attempt to restyle the Italian Taxpayer Bill of Rights actually in force. But those proposals, like some others suggested this year, have to cope with the constitutional perspective and its evolving process as an avoidable requirement. So how to pragmatically operate in that direction? Here, some specific inputs. The fulfillment of the principle of cooperation described at Article 10 of the Italian Taxpayer Bill of Rights, which reveals, thanks to the Australian partnership model, the international accepted idea of a partner taxpayer is useless as a parameter of constitutionality. But it's now compiling facing a new step to go further, endorsing the taxpayer potentialities in his being a person propellant of new institutional dynamics by his individual choices. Each system, even beyond the precedents of the American and Australian experiences, in different jurisdictions, we cannot ignore that each system has been called to give some sort of answer to its own citizens in terms of balancing freedom with accountability of the whole system. The constitutional background described in this speech has revealed, above all in the Italian experience, all its potential to make individual choices. Obviously, being taxpayers' preference, the fundamental criteria to judge the way the taxpayer is taken into consideration by tax administration in upgraded perspective. That will introduce a legal consideration of freedom itself as choice and value beyond its formal safeguard. In that perspective, in fact, he who pays has the right to vote, to choose, and can claim to control the action of a representative. The aim is to generate a competitive context for obtaining the best possible service as possible from tax authorities, thus fostering the repositioning of the axis of choices from tax authorities to taxpayer. In that context, a figure totally dismissed in the Italian context is the taxpayer advocate that has to emerge. Peculiarities summed up in this slide show that functional powers and transparencies have to be granted to push the taxpayer advocate to realize an effective interaction with taxpayer in order to open the door towards him. Taxpayer, according to recent fraudulent tax administration strategies, has not simply to be involved, but has to be engaged. I mean, the engagement that Professor Benedict talked about, mentioned before. That means that the search for the best, and I'm concluding, the search for the best model assuring the effectiveness of taxpayer rights has to be driven by a relevant consideration of the comparative perspective by means of a constantly involved dialogue for the advancement of constitutional progress. The main outcome will be the progress of ideas and thus of solutions. But those solutions has to be determining in their ability to provoke the surfacing of different perceptions in the design of crucial issues. Comparison, as a current Italian Constitutional Court Justice Paolo Grossi affirmed, comparison served to intensify critical insight. And the sense is that comparison with a subsequent exploration of different experience cannot but help focus any issue and reach a common aim, though not meaning mere standardization. It helps advance changing culture, means, options, and practices. From a progressive constitutional perspective, we have to think of changes as salutary for citizens in a democracy if they are justified by an improvement of dialectic dimension of the institutional dialogue. To fulfill these purposes, we have to consider our own constitution as something in need of fuel to move, in need of dedication, spirit, and responsibility. The appropriate approach for taxpayers' rights is, in fact, a consideration of their role as a matter of interpretation, especially constitutional interpretation. For the purpose of effectiveness, that kind of interpretation has to be considered binding for the interpreter. A pragmatic point of reference in tax field to find the balance between responsibility and freedom is, moreover, the action of a propelling and creative taxpayer advocate. That's why the taxpayer advocate, and not the law, can become the true turning point for the effectiveness of taxpayer rights. Effectiveness that, on the ground of taxpayer rights, properly within the constitutional interpretation and process, Effectiveness that demonstrates we are safeguarding the essence of the life of the state and the linchpin of our constitutional democracy. What is the essence of the life of the state if not the constitutional premise, the lifeblood that links the taxpayer with government even beyond the law? Thank you.
Thank you, Giovanna, for that talk with chock full of ideas we'll be talking about in a moment. I would now ask the Alexis de Tocqueville of tax culture, Mr. Thorndike, to give us his presentation.
I know. That's all right, I brought my notes.
I don't think he even heard what I called him, or what Amity called him.
Amity was entirely too nice on that. And, you know, that's a product of marketing people at the presses. But I'm going to step back a little bit from theory to tell a story, like most historians. I'm going to try to tell a story in a particular case study of the United States with a focus on the experience of American taxpayers. So I'll get to the title of the project and why I call it that in a minute. I will just start by saying that there's an American taxpayer, happens to be a United States Senator, Pat McCarran from Nevada, best known for being an ardent anti-communist and the author of some really kind of shocking bills, but also a taxpayer and quite obviously frustrated by his taxpaying experience, and this is in the mid-1950s. Okay, so my question here is, what do we know about the history of taxpaying in the United States? I'll back up for a minute and say first that the sort of predecessor question might be, why do we care about the history of taxpaying or any sort of history when it comes to policy like this? There are lots of reasons why people care about history and they shouldn't. People like to use history for affirmation, to convince everyone else that they were right all along, and history will show you why. People like to use it for predictions. Well, you know, this happened before, or this didn't happen before, so therefore we can make all sorts of predictions about what the current policy should be. Also not good for that. The value of the history here, as it applies to policymaking, I think, is because it extends our view. We tend to take a sort of narrow view of what's possible, and I think that history expands our notion of what's possible by showing us, hey, there were options before that may not be on the table now, but worked then. They may not be practical now, but they may. At the same time, it limits our expectation of what's likely. It will poke holes in the grand plans of major tax reformers, those who hope for wholesale replacement of the tax system at any given point in time, for instance, can find very little hope in history. But I think that that's, I've almost want to trademark this phrase because I use it all the time. I do think this expansion of our notion of the possible and this limitation of our sense of the likely is what the history brings here. So what do we know about the history of taxpaying in the United States? Essentially nothing. We know quite a bit about the creation of tax policy. In the last 15 years, there's been a real rebirth of what we all call fiscal history because everyone tries to dance around the word tax. It turns off so many non-tax people. Not a problem I have here. But there has been a rebirth of fiscal history, but very much it focuses on the making of tax policy. There's been very little written by historians about the operation of the tax system, at least beyond sort of broad measures of revenue collection. And I don't really need to try to sell this idea here. I did try to sell it last week to a bunch of graduate students, and I tell you, I sold nothing at all. I was completely unsuccessful. I don't need to tell anyone here that tax administration matters, not only to the state, but also to the taxpayer. It scares historians, I think, and by historians I include political scientists and sociologists, partly because it just seems incredibly tedious. But even more important, I think there's a very thin paper trail. How do we get at the lived experience, as I come to on the next page, of a taxpayer? Incidentally, these are advertisements that have run over the years. These are historical advertisements that show the degree to which tax-paying figures in popular culture in American society, and I think in many societies, but we still don't know much about it. I think that the voluntary elements of tax compliance make that story of the taxpayer's experience very important. It's not in our historical memory. As I said, it's a hard story to tell because the sources are scarce, although it's hard to tell any story in social and cultural history. But it's too important to ignore. So, I like this quote quite a bit because I think that this advances us to understanding the process. This is a quote from Justice Robert Jackson, who was a Supreme Court justice in the United States, but also was a tax collector, worked for the Bureau of Internal Revenue and for the Justice Department's tax division. And what he had to say was, the United States has a system of taxation by confession, that a people so numerous, scattered, and individualistic annually assesses itself with a tax liability, often in highly burdensome amounts, is a reassuring sign of the stability and vitality of our system of self-government. There's another part of this quote that may be even more on point here. It comes immediately after, and he says, "What surprised me as a person who had worked in tax administration in once trying to help administer these laws was not to discover examples of recalcitrance, fraud, or self-serving mistakes in reporting, but to discover that such derelictions were so few." So I came across this quote, which is a favorite among a certain kind of historian, while I was engaged in another project, which is looking at this question of compliance, and particularly the question of why certain countries are more compliant than others, or appear to be. And there's research being done on this. There's actually experimental research being done on this, and there's obviously over the years been quite a bit, but the historians and the fiscal historians are sort of catching up to this now. They're trying to wrestle with what I call the original conundrum of American fiscal history, which is, for a nation born of a tax revolt, and that's a picture of the Boston Tea Party, the original one, not the one we have today, Americans are remarkably good about paying their taxes. I'm now going to set up a straw man so that I can knock it down immediately, but there's an undeniable strain of anti-statism and anti-tax ideology in American political culture. The problem is that it's not nationally exceptional. It's not unique to the United States. As someone pointed out to me last week, every country is convinced that their tax-paying system is the worst and that they hate it more than anybody else. But not every country has made tax resistance and anti-tax ideas so central to their national historical memory. From the Boston Tea Party to Shays' Rebellion to Proposition 13, all tax revolts in the US, we have this notion of Americans as tax revolters. Or revolting taxes, I don't know, something like that. And yet, and here I won't get too specific with the numbers because I haven't been able to really identify ones that work for me too well, but Americans do seem to be among the most compliant taxpayers, at least for the income tax in the world, and to report relatively high levels of tax morale. So to say, as Oliver Wendell Holmes observed, taxes are what we pay for a civilized society, as Nina pointed out earlier. For more than 200 years, America's compliant taxpayers have been remarkably willing to pony up. Why we pay is another question. I think that Justice Jackson's notion of confession is helpful. Tax compliance, and by extension, tax consent, and I consider that a broader term, is a function of both voluntarism and coercion. They're sometimes in tension, but usually complementary in the US experience. So this project tries to look at compliance and consent in two particular time periods, taxation in the crucible. That's the Civil War with Abraham Lincoln over there, and World War II, which, as Chris noted, I wrote a book about, so I love that period. These are special cases, and in some ways not great to look at historically speaking, because they're really exceptional. Wars have all sorts of patriotic fervor around them that changes the process of tax paying some. But they are also moments of creation. In the Civil War experience, there is no income tax in the United States before the Civil War, and suddenly, within months, they have to create an income tax and create a nation of taxpayers to pay it. The same goes for World War II. There was an income tax, but paid by very few people. In about 5 years, they increased the number of taxpayers sevenfold. You had all these inexperienced taxpayers, and you had to make sure that they knew what they were doing, that they would actually remember to file their returns, to actually pay their taxes. What we really need is a look at peacetime periods as well, and my project tries to offer some thoughts about that, particularly in the period after World War II, but that's in the end of this, that's really a mammoth undertaking because it's a comprehensive history of the IRS. And I'll take this second to say, this is a parochial American comment, but there is no history of the IRS in this country. No one has ever written a history of this agency, despite the fact that it's one of the largest federal agencies in the US, despite the fact that it touches the lives of Americans more directly and more coercively than any other federal agency for most people. We still have no single history of it. Former chief counsel once came to me and said, why is this? You should write a history of the IRS. And I said, well, find a publisher for the history of the IRS. That's the first problem. But the problem is there's no paper trail for it. There's not much of a historical record. We can't let that dissuade us. So we press on. So anyway, this is the argument that I'm making here about the paper, in the paper. I argue that consent, broadly conceived, was a function of both coercion and voluntarism in both these periods and outside these periods. I focus on tax administration, but I try not to ignore policy because I believe policy is a really important part of the equation. Policy was an element of voluntarism since fairness perceptions were crucial to consent. It was also an element of coercion since lawmakers choose some taxes because they're easier to collect than others. I try to accommodate the blurred lines and the interactions. Some forms of coercion, like withholding, which I will talk quite a bit about, obviated the need for voluntarism and actually had voluntaristic qualities themselves. Some forms of voluntarism, such as the social pressure to pay taxes in wartime, are at least quite a bit coercive at times. I ultimately conclude that coercion cut two ways in the American experience. It fostered voluntarism by reassuring taxpayers that they weren't chumps, that it sort of cuts down on the free rider problem. And this is crucial if you're going to maintain voluntary compliance. It also, however, undermined consent by embittering taxpayers. The income tax is, as critics have been saying for 200 years, inherently invasive and inquisitorial, and its enforcement is irritating to taxpayers. This was especially true in the Civil War. But the paper concludes that durable consent, especially in the period after World War II, depended heavily on aspects of tax administration that blend coercion and taxpayer assistance. Withholding, in particular, is obviously coercive. You know, it involves taking the money before a taxpayer even gets their hands on it. But it's also was regarded at the time as a boon to taxpayers who had relieved of administrative difficulties. And I think that sort of coercion with a velvet glove is especially important for complex taxes like the income tax. So I'll go through and try to explain a little bit of that. How long have I been talking, Chris?
Only about 5 or 10 minutes.
Oh, that's great. Then I won't rush, which I'm sure will relieve everyone here because I get hard to understand. All right, voluntarism, elements of voluntarism in the Civil War. Well, there was obviously policy design was a key factor here. The income tax in the Civil War was designed to bolster fairness. Up until that point, almost all federal revenue in the U.S. was collected using tariff duties, and these were known to be quite regressive. And there was a sense that if Americans were going to be willing to accept a much higher tax burden, such as the war desired, then fairness had to be served. There had to be some gesture toward progressive fairness. There were concerns that the Civil War was a rich man's war and a poor man's fight. That had a lot to do with how they drafted soldiers during the war, but it also applied to the tax system. And when they tried at first to come up with a tax system that did not include an income tax, people objected. And there was a great quote from one member of the House of Representatives, and he says, "There is no stress of weather," which is a phrase I don't know what that means, but it seems so wonderfully 19th century. I like to keep it in there. "There is no stress of weather which can induce me to vote for a bill as it now stands. I cannot go home and tell my constituents that I voted for a bill that would allow a man, a millionaire who has put his entire property into stock, to be exempt from taxation, while a farmer who lives by his side must pay a tax." They were proposing a national property tax as an alternative. So they introduced the income tax in an effort to bolster the perceived fairness of the tax system as a whole and to therefore encourage better compliance. At the same time, they used decentralization as an element of voluntarism. They had to build a Bureau of Internal Revenue, a linear forerunner of today's IRS. In fact, the only thing that changed was the name in the 1950s. They did this by not using state revenue collectors who were out there and ready to be used. And many members of Congress said, hey, you should outsource tax collection entirely to the states. But they instead decided they would build a federal agency, and I'll come back to that in a second, involving numerous collection districts all around the country. This would put, they thought, a local face on a federal tax. If you knew your tax collector, you might be more inclined to pay. It also gave the president and Congress ample patronage, so they could appoint millions, or not millions, but hundreds of assessors and collectors and their assistants to collect the tax during the war, and that helped embed the system as well. There was obviously a patriotism element of voluntarism, as there is in every war. This is a quote from the Treasury Secretary, and he says, "The most sacred duty of every American people at this moment requires the consecration of all their energies and all their resources to the reestablishment of the Union on the permanent foundations of justice and freedom," which is just one of countless invocations of the goodness of the American people and why they would willingly give, which by and large they did. There is this element of voluntarism involved in building the infrastructure for paying the tax. I call this sort of administration from the ground up. The first Commissioner of Internal Revenue, who's right there, George Boutwell, began with absolutely nothing. He was actually in Egypt when they passed the law imposing the first income tax and creating the Bureau of Internal Revenue. He shows up a couple weeks later and he reads the law. No one's really read it to him. He has no experience to it. And within a few days, he starts to hire people, and in about 9 months, he puts together the Bureau of Internal Revenue. The people, there was quite a bit of resistance to this. There was, as it says here, lots of confusion about what the new tax would involve, and letters were pouring into the Treasury every day. And at first the commissioner answered all these letters personally, which is sort of amazing to imagine right now, especially when a fair number, say 5% of the population was paying the tax. But his first principle at the time was to levy a tax in those cases only which are clearly provided for by the statute, and consequently, whenever a reasonable doubt exists, to rule against the government and in favor of the individual. This was very much an effort to reduce the friction of introducing the new tax, to always give taxpayers the benefit of the doubt. That impulse did not last all that long, not even during the Civil War, but I think it was sort of crucial in the early days when resistance was likely to be, the most serious. So, Boutwell builds this new Internal Revenue Agency, and there's an enormous amount of resistance to it. People call it an army of officials. Over and over again, they use this martial terminology to refer to all of these new tax collectors that are swarming the country. This decision to use federal tax collectors rather than state tax collectors rankled, at least with many Americans at the time. It didn't help that the agency was given sweeping powers. They could, if you failed to file your return, they could file the return for you and simply make a guess about what you owed. If you didn't comply with that, you were subject to arrest and imprisonment. They offered bounties to tax collectors. Those appointed assessors and collectors got a share of your taxes as their pay. And they actually, this will ring bells in this room, no doubt, they hired private collectors to do the job as well and gave them a share of taxes paid. This did not sit well. And one member of Congress says, quote, "One of the most obnoxious, perhaps the most obnoxious of all the law's features is that which creates an army of officers whose business it is to collect this tax." And this was the best defense that a supporter could come up with. He said, "It is unpleasant to send the tax gatherer to the door of the farmers, the mechanics, and the capitalists of the country to collect taxes for defraying the expenses of this war." But he said that they were a necessary evil and administrative necessity given the range of new taxes. So it was a sort of grudging a defense of it. As an effort to boost compliance, they actually encouraged public disclosure of tax information. Everybody's tax bill, their assessment, and how much they actually paid was available for public inspection. The IRS was required to, or the Bureau of Internal Revenue was required to release it. And the explanation was really quite clear. The object of the law seems to have been to afford every taxpayer an opportunity of ascertaining what returns his neighbors have made. He is interested in those returns because the burden of the national duties is a common one and every person should be required to pay his due proportion. So this is that notion of trying to combat free riders on the one hand. You have a right to know that other people are actually paying. It was also a way of auditing taxpayers when we didn't have the the administrative capacity to audit them directly. The idea was we would turn every person into a tax collector. You would be your neighbor's tax collector. If you weren't paying enough, if you were not declaring enough income and your neighbor suspected as much, by looking at the tax rolls, they could report you to the Bureau of Internal Revenue. Incidentally, you can't really see it there, but that's a list of an assessor's rolls. And I think the 1, 2, 3, 4, fifth one down is Abraham Lincoln's declared income for that year. It lists his address as the White House. All right. Withholding, which I'll mention just in passing here. They gave it an experiment in the Civil War. They withheld taxes on government salaries, including the president's salary. Later decided that was unconstitutional. But federal salaries were subject to withholding, as were some bank dividends and some of the corporate tax that was enacted at the time. It was not, however, a big part of it. The Civil War tax consent did not last. So all those systems, the voluntarism and the coercion, did the job during the extremity of the war. But the coercion in particular cut two ways, both of them against the income tax. At the end of the war, when they're deciding whether to hold on to the income tax, they say, the problem with the coercion is that there was too little of it to actually prevent evasion, and yet there was way too much of it for anyone to tolerate. That's a really no-win situation and not an unusual one. I think tax agencies have that problem almost always. The voluntarism was successful in the sense that, especially the patriotic appeals and that come during wartime, were quite effective. And I think administrative support provided to taxpayers through this decentralized system of tax collection was also remarkably successful at the time. The proliferation of this army of officials, they actually did their job. But after the war, pocketbook complaints, people just simply not wanting to pay the tax, and they happened to be wealthy because the tax was only paid by about the top 10% at the end of the war. Those merged with the coercion complaints, which really ramped up to a deafening roar to undermine the tax. And then when they didn't really need the revenue quite so much anymore, that was an opportunity to get rid of it. Again, to come back to the coercive element of it, the complaint one member of Congress made was, a tax bill like this goes into every house, every business, every neighborhood, takes everything a man eats and all that he wears, which enters into the consideration of every man engaged in every business of the country. It really was seen as horribly coercive. And that doomed the tax. It was just too coercive for American society at the time. I'm not actually going to play the song that goes with this slide. It never works in PowerPoint. I don't even know why I leave it in here. But I will tell you about it. So, this is the voluntaristic aspects of World War II. Policy design, again, fairness was used as a tool of consent. They had to dramatically expand the income tax during the Civil War, during the World War II, and they justified this to the new middle-class taxpayers by raising tax rates on the rich, very high indeed. They reached 94% near the end of the war, marginal rates of 94%, and actually effective tax rates of nearly 60% for the top 1% of taxpayers in the US, which is really quite astounding in retrospect. Just as important to this element of policy design, there was no national sales tax in the United States and never has been since. And actually, that's an aspect of sort of path dependence. The decisions, I think, that were made during this World War II to not create a national consumption tax, broad-based consumption tax of any sort, have proven to be remarkably tenacious in the US, and I think actually directly explain why there's no value-added tax in the US. But again, this was the idea that progressivity would improve consent for the new income tax. There was, again, a patriotic appeal framed in terms of sacrifice. They used mass media. That's a picture of Donald Duck. They made a couple of Disney cartoons with Donald Duck paying his taxes. The song you won't hear is a song by Irving Berlin called "I Paid My Income Taxes Today." This was wartime propaganda, nothing more, nothing less, but really remarkably resonant and effective at the time. As a historian, a legal historian, Carolyn Jones, who's done some really outstanding work on looking at how they created this tax-paying culture with these mass media tools. There was an effort to improve, to provide information and taxpayer support for these new taxpayers, but this was wartime, and there wasn't a lot of manpower available to increase the size of the Bureau of Internal Revenue. These are just a sign of how they tried to, the elements of the propaganda campaign. The taxpayer support was gentle, and as was the coercive element. There really were very few overt threats. That's partly because coercion requires either a small scale, like the Civil War tax that applies only to a few people, or really truly impressive administrative capacity, which the Bureau of Internal Revenue didn't have. They did offer threats, got to pay or you're going to go to jail, that sort of thing, but they were sort of underdeveloped during the war. And the Treasury Secretary knew why, because their administrative weakness made it dangerous. People might call their bluff, and as he said, suppose we have to go out and arrest 5 million people. I mean, it was obviously impossible. So they took it easy on the coercive elements during World War II. After the war, that story changes a little bit. Absent the wartime patriotism, the exhortations that proved effective to keep compliance high during the war, the Bureau of Internal Revenue turned to threats. And they weren't just threats against rich people. You know, there's often the thought that the IRS targets rich people because it makes a big splash and will show everyone just how serious they are. Actually, after World War II, the Bureau of Internal Revenue explicitly targeted little guys, and they had the commissioner going out and saying, yeah, we could go after the big ones, but we're going to get that guy right there. We're going to look way down the chain, because that was what they felt was needed to enforce a mass tax, was to instill some fear in the average taxpayer. The most important element of coercion during World War II was withholding on a grand scale, and it really changed the equation. As I used this phrase earlier, coercion with a velvet glove. There were real concerns that these millions of new taxpayers would have no idea how to pay their taxes, or even that they were responsible for paying their taxes. And that was hence the worry about having to arrest 5 million people. And it really, withholding made it all possible. And they enacted the broad tax before they enacted withholding, but they knew that it was necessary because you simply couldn't create taxpayers that quickly out of whole cloth. So I do think that the coercion, that the withholding is what made what made the World War II tax really go. And more important, it's what kept the tax going after the war. There's a decent argument to be made that the tax regime that they established during World War II is still with us today. There's a decent argument to be made that it's changed so much in the details that it isn't really the same regime. But I think in terms of having a mass income tax on individuals, it really is still here. I think the progressivity of the tax was crucial to its durability after the war. People like Dwight Eisenhower here, Republican with a Republican Congress for several years, chose to leave the tax almost intact, including its sky-high marginal rates. And I think that was because the progressivity arguments had proven quite successful and quite compelling. I think that also the mass tax, by virtue of its embeddedness, by the fact that so many people were paying it, suddenly it was being embedded into the structures of everything else in American society, and increasing elements of the post-war state were delivered through the tax system. Healthcare comes as a mind, employer-provided healthcare, because that came during and right after the war. But again, I think that withholding was crucial, because I think that it managed to coerce tax payment, but do it in a way that taxpayers were remarkably tolerant of. I think the issue here really comes down to complexity. There's many people in Washington say, this is always everybody's second highest priority in tax reform, and certainly when it comes to politicians, that's true, but I don't think it's true for taxpayers. It is the great hope of taxpayers, but it's almost always frustrated. Jumping back to withholding for a second, at the time it was conceived as a benefit to both taxpayers and the government, because it reduced if not the complexity of the law, at least the complexity of the tax paying. In doing that, it facilitated voluntarism. It limited the possibility of catastrophic error, the getting arrested by the Treasury error. And the tax, because the income tax is inherently complicated, at least for some taxpayers, there was real fear associated with it. And I think, as I say at the end there, fear is the enemy of tax consent. Complexity breeds it, especially when combined with coercive forms of enforcement. And withholding was designed to sort of coercively collect the tax, but without that heavy-handed and threatening governmental intervention. I think policymakers were clearly worried that taxpayers would withdraw consent from a system that they found confusing and that also required taxpayers knocking on their door. So, looking forward, I think that what does this history have to say to us now? I think that it encourages us to take seriously the taxpayers' desire for simplification and certainty. I think that genuine simplification reforms are crucial to maintaining and developing tax consent. And to the extent that in the United States today, we see some significant erosion in tax consent on the federal level, certainly, but really at every level of government, I think it's partly because the income tax is considered so complicated and so threatening. In more specific terms, I think that it means that policymakers need to look for ways of reducing the friction of the tax-paying process in the way that withholding did. That might be going forward sort of pre-populated returns for taxpayers who can benefit by them. I once wrote an op-ed piece called "Hurts So Good," arguing that the pain of paying tax I didn't write the headline, that's a headline writer's claim to fame, but arguing essentially that the process of tax paying should be a little bit painful, that it encourages some engagement with the governing process. And I still, on some abstract level, agree with that, but the history of taxing in America suggests to me that tax consent depends on not hurting too much, on using those techniques, even if they decrease engagement with the governing process to some degree, making better use of techniques that limit the friction are important if we hope to maintain tax consent. I think also we need to better advertise the simplicity that already exists. For many taxpayers in the US, the income tax is not particularly complicated, and yet it enjoys a reputation for being very complicated. It's astounding to me that no one has actually ever decided to put the 1040EZ on a postcard. I mean, it sounds trivial, but we actually have fairly simple tax filing procedures for many taxpayers, and yet that message doesn't really get through, as evidenced by the fact that something like 40% of 1040EZ filers use a paid preparer to do their returns. I think that even when complexity doesn't reduce compliance, even when people are scared into complying, or when, even when the coercive elements of tax collection are enough to keep compliance reasonably high, I think that it does erode tax consent more broadly. And in the US, that may be the bigger problem going forward, is not our tax compliance level. We may want to close the tax gap, make it smaller, whatever it might be these days, 83% compliance, something like that is our current number. I don't really think that is the biggest issue. The biggest issue is that the tax system as a whole is losing the broad social consent that supports it. And I do think that finding ways to simplify and reduce the frictional elements of the tax-paying process are the way to preserve that tax consent.
Thank you, Joe. We have about 10 or 15 minutes left here. I have read all of their presentations and have a number of questions. I would encourage anybody who out in the audience who has questions to please use this time to ask them. And I think I'll start myself with a subject that's near and dear to my heart as a former philosophy student. And I found that each of your presentations proceed in what I would call fundamentally an Aristotelian manner. Rather than reasoning from a priori principles, you each sort of looked at historical examples or practical examples of taxpayer rights the way Aristotle does in the Politics, to deduce from that what kind of good general principles one might implement as a taxpayer rights system. And I want to ask you to see if we can sort of turn that on its head. And I know, Duncan, for example, in your book, you talk a little bit about taxpayer rights as derived from property rights. But I want to ask each of you what you think the basis for taxpayer rights in the abstract, and we'll get into particulars in a little bit, is. Is it social contract theory? Is it natural law and property rights? Is it utilitarianism, which is something that is an issue that is a rationale that is often offered for various rights, and I'll talk about that in a minute. But can you each comment on that kind of initial point, so that we just sort of have a basic frame of reference of what your conception of the fundamental theoretical source for taxpayer rights is?
Well, I'll start. I suppose my concern with the question is that as soon as you say that there is a certain philosophical basis for the origin of taxpayer rights, that can then box you in to say that if you don't subscribe to that philosophical position, then those rights don't exist. And that, I suppose, is one of the things which, deriving from the 1948 Declaration of Human Rights, essentially we said that if you look at any philosophical system, there are certain fundamental rights which can arise from those theoretical bases. And so, yes, one might have a particular view which will skew your view of the way that rights should go, but fundamentally we can say that as human beings, whatever philosophical theory we subscribe to, there are certain fundamental rights which accrue. It then goes to, well, if you're looking at a fundamental basis for rights, then how do you develop those within each of the systems? And each system will then, in my view, if you've got the rule of law and you derive from property rights, you then build it up in accordance with the legal jurisprudential approach within your own system. And whether or not you're talking about it from a positivistic approach, that you've got a closed system where you have recognition of the way that rules are derived, the Constitution, and it's derived through parliamentary democracy, or whether you take it even going to someone like a Long Fuller type natural law approach where you derive it from the origins, I mean, as Grotius did with the origins of international law from natural law, you can come down to a position which then allows you to build a system which we've been describing. And I suppose that's the reason for the more Aristotelian approach from my perspective.
Yeah, thank you for your question. Actually, I think the basis for talking about taxpayer rights, it's not just their philosophical basis, but their inner soul. I mean, the core of taxpayer rights is their way of introducing the individual and the network around individuals, like the accountability network I talked about, and the system. That's it, just to reinforce the idea of human being and their dignity within the system. So it's not just a philosophical point of view, but it's the way to to emphasize the basis of human soul within an institutional system.
Well, just to get parochial again, and looking at the U.S. experience that I just described, I think that the tax-paying and taxpayers' rights were embedded in an ideological tension that many historians see in American society existing over long periods of time, which is essentially liberalism with an emphasis on property rights versus republicanism, meaning a fear of corruption and a sense of social responsibility to your fellow citizens. And I think in terms of my story, the voluntaristic elements of tax-paying are rooted in that liberal tradition for the most part. You hear it in that quote from, with my taxes I buy civilization. There's a value proposition there, and it's clearly voluntary. I'm buying civilization from you, the provider, the government. And that, I think, is what the voluntarism is rooted in. And then the coercive elements are often rooted more in the republicanism. This fear that some people are getting away with murder, some people are free riders, we need better enforcement to prevent that, and that we have a social responsibility to one another that you can't get out of simply by claiming, I'm not interested in that part of government, I don't want to pay those taxes. Not actually an option in a Republican government where people have responsibilities to one another. So I would locate it within those two traditions.
I want to give an example, though, because something near and dear to my heart, and I think we have a panel on it. I think it may actually be the next panel is about transparency and confidentiality. And when I was in the government, and as I've seen subsequently, discussions of the value of our privacy and confidentiality provision tend to be justified ordinarily in utilitarian terms. They say it fosters voluntary compliance. How many times have you had a debate about a tax procedural issue And the question is always which way fosters compliance more. But I've always found that troubling because you can always just turn it on its head if an aggressive enforcement of the law that doesn't take into account taxpayer rights actually does foster more compliance, then why isn't that the right answer? So I've always tried to shy away from that argument for that reason. And I think it's interesting that all of you did that. I also wanted to offer a thought that I think, Joe, really came out of your piece, which is there's sort of a Laffer curve of compliance, you know, because if there's no compliance, you're not going to get, if there's no coercion whatsoever, you're not going to get any revenue. And conversely, if there's too heavy a hand, you're going to get fierce resistance to the revenue. So there's sort of a Goldilocks sweet spot in there somewhere where you maximize revenue with a certain amount of coercion and a certain amount of recognition of fundamental rights.
And the problem is that it's going to be incredibly difficult to find that sweet spot. So in the Civil War, as I said, they ended up having both too little and too much coercion. And so it's really, I think you're absolutely right. I think the voluntaristic elements of taxpaying do depend on the coercion to prevent free riders. But it's devilishly hard, I think, to find that point.
I'll keep asking questions if you don't have any, okay?
This one.
Oh, we do have someone. Oh, okay, yeah. Well, you can ask and I'll repeat it.
My name's John Friedenberger. I'm a tax practitioner in Paris, France. First, I want to congratulate the panel on the presentation. You've got the conference underway in a wonderful, remarkable way. Chris, back in 1996, you helped formulate the Taxpayer Bill of Rights. We now have a new Taxpayer Bill of Rights, thanks to Nina, for 214. My question is it enforceable? The IRS is closing its remaining 3 posts overseas before the end of this year. I think the 8.5 million expatriate Americans have a reason to feel that their quality of service provision of the current Taxpayer Bill of Rights is being violated, basically. What would you recommend they do?
All right, well, there was a lot in that question. First of all, I won't necessarily take any responsibility for anything, okay? So, unless forced. I was involved in the 96 Act, and you make the point that the IRS is cutting back its available resources to 8.5 million expatriates in the United States. But I think your question, the real heart of the question you asked is, from a theoretical perspective, is are taxpayer rights provisions enforceable and how? And I found interesting in each of the papers here that they sort of danced around that question of, can you have, I mean, it's a truism in common law, right? You can't have a right unless you have a remedy, unless you have, you can get something out of it. And we were very careful in 96 and 98, in all candor, to be very careful about which of the rights in the Taxpayer Bill of Rights did have remedies. Not a lot of them do. And certainly what Nina has proposed and the service recently promulgated, which is more of a declaration of rights rather than anything that's sort of specifically enforceable, doesn't have an awful lot of remedies attached to it. So I actually have the same question for our panel is, can you have these, what you call soft law or pragmatic rights, do they have any meaning whatsoever unless they have remedies attached to them?
Well, I'll start. Yes, they do, but they're not as strong as hard law remedies. And that's where you have the importance of ombuds, taxpayer advocates, the importance, as I said, of monetary democracy, where we are monitoring through transparency the service standards, where revenue authorities will hold themselves to account to respond within certain times to queries from the customer and to make sure that those are published. And if it goes below a certain level, then it comes back to the legitimacy question. This isn't fair. We're being taken for a ride. We're no longer going to comply. Therefore, that in itself is a soft law sort of check and balance, but there are very limited hard law remedies.
Yeah.
I completely agree with Duncan, and that's why I pointed out the real turning point with the taxpayer advocate in a system and the monetary vigilance of constitutional courts to, just trying to keep effectiveness on their rights. Otherwise, if there is no way to let them rights consistent with Constitution, it's like not have a Bill of Rights.
I guess historically, I would say that that the tax system hobbles along, even with few remedies for enforcing taxpayer rights, and certainly complaints about IRS, about tax administrators' inadequate support for tax paying overseas or anywhere else. Actually in 1913, they didn't even distribute forms overseas, but still required people to file, which was really a trick. So I think complaints about that kind of inadequate support are common. And generally, I think the historical record is that there are remedies available, and they're often inadequate, and the system hobbles along anyway. But that kind of thing undermines taxpayer support over time, taxpayer consent.
I think our time is up. I would love to continue this discussion. I'm sure we will, and I hope we have an opportunity to engage with all of you. I want to thank our panelists and Nina and our sponsors for this conference.
Thank you.